someone takes it upon themselves to add on a sixth floor where they're all one-story units, and the association will come in to enjoin further construction. That kind of area overlaps into the area we all know and love of nuisance, and that can be anything from somebody doing a property modification in the form of adding on a chimney that's going to be in such a position that smoke goes over somebody else's yard, or to the commercial situation where the conduct of some business is creating a nuisance to the surrounding landowners. Another common area is unfair trade practices. The most common there are customer list cases where a departing employee or partner or anybody with any access to a customer list leaves, takes it with him, tries to solicit other employees to leave and join a new employer. I just would point out to all of you that there is now in California a uniform act governing trade practices and trade secrets and all the other things that fall into that category. Most of the case law on the subject was decided prior to adoption of the act, a fact which conveniently escapes most lawyers when they're preparing points and authorities on this subject. Another subcategory here would be seeking an injunction to restrain someone from inducing breach of contract. There is some case authority permitting an injunction in that area. It's a hard one to prove. All of the ones under the heading of unfair trade practices are very difficult injunctions to get, and they are the prime example of what Peter's talking about when he says it can be a very expensive proposition to come in for an injunction. There are, of course, labor disputes. I'm sure you've all read and heard the news over the weekend about various courts throughout the country issuing injunctions regarding the airline strikes that are going on now. And some of those are federal issues. Others are more local, where a superior court will be asked to impose reasonable restrictions on the method of picketing, the number of pickets that can be used in items like that. Occasionally, we're asked to restrain enforcement of a local ordinance or some criminal statute, either because it's unconstitutional on its face, sometimes because it is unconstitutional as applied. Again, that's an uphill battle. The other kind of property cases that I skipped when I mentioned the earlier group would be the neighbor dispute, where the judge sits really more as a mediator than as a superior court judge. I'm talking now about barking dogs and shrubbery growing onto adjacent property. And it always seems a pity to me that people are spending so much money to fight this out. And when you have one of those cases, my suggestion would be to explore alternative forms of dispute resolution through some mediation program, because I start calculating what it's costing the clients with two lawyers sitting in my court for protracted proceedings over a barking dog, and they could all go out and buy a kennel for what it costs, I think. With those major areas in mind, Diane's going to talk now about the burden on the moving party who's coming into court for a temporary restraining order. We're going to go through and do moving party for a TRO, opposing party for the TRO, and then the court's views on that, and then we'll go back and talk about the preliminary injunction, just so you know how we're dividing this up.
In order to talk about how to prepare for TRO, I thought it would be helpful to have a fact situation, and so you have a number of the papers that you would file starting page 129 of your materials that relate to this fact situation. A tenant contracted with a landlord to rent some space in an office building that had a very wonderful view. The tenant said to the landlord, I'm going to rent this space instead of some other space because of this wonderful view I have of a golf course. And unbeknownst to the tenant, the landlord had already decided to put up an opaque film on the windows that would cut out the view after the tenant was moving in. The tenant, upon receiving notice that this was going to happen, runs into the court and requests that the court issue a temporary restraining order stopping the landlord from putting up this opaque film. Now, when a client comes into your office to talk to you about a TRO and telling you about the emergency need that the client has, there are a number of things that you need to talk to the client about before you get into a very detailed discussion of the facts. First, as you've already heard from both of the other panelists, you really want to talk about expense. In the fact situation I've posed and what the real set of papers would probably look like, they'd be a little more voluminous than what's in front of you in the materials, you could be talking about a $25,000 temporary restraining order through preliminary injunction hearing. And a client needs to know that. The client needs to understand that in a temporary restraining order, you may be spending in a matter of 2 or 3 weeks what you would ordinarily spend during the course of an entire lawsuit, because essentially, by the time of the hearing on the preliminary injunction, you may have done expedited discovery and essentially proved up your whole case by the time of that preliminary injunction. So instead of in LA spending 5 years in the process, your client could be looking at spending that very abbreviated time up to the hearing on the preliminary injunction.
This is the end of the first half of the first cassette.